Sometimes major Supreme Court cases involve the Second Amendment even when it's not obvious to the outside observer. That is the case with the case of Moore versus Harper, a case before the United States Supreme Court arising out of the state of North Carolina. Stay tuned why this matters to your right to keep and bear arms. Hey folks, I'm Mark Smith, host of the Florida Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. We're trying to get to 100,000 subscribers as fast as possible because it's going to make a big difference for us and the algorithm if we can get to those numbers. All right, folks, so here's the story. There's a U.S. Supreme Court case that just got argued called Moore versus Harper. Sometimes we want to talk about rooting interest. There are certain cases and issues that are out there in America that are important for our right to keep and bear arms, even though it's not specific to the right and keep and bear arms because of sort of the ripple effect on it. For example, winning and controlling the United States Senate doesn't directly speak to the Second Amendment, but being able to control the United States Senate, for example, with people that like guns, is better than the opposite. So this is an example of what we're talking about here. So there's a Supreme Court case called Moore versus Harper that was just argued. I want to talk about this for just 2 minutes, make you aware of it. So in Moore versus Harper, this is an extremely important case for the Second Amendment for multiple reasons. First of all, it's a case that's requiring the United States Supreme Court to engage in originalism, which is what we want them to do. Originalism says that the United States Constitution, including the Bill of Rights, including the Second Amendment, should be understood when it was enacted in the late 18th century, and that is how it should be interpreted. And Moore versus Harper is a case where this is a big deal. And why is that? You see, under Article 1 of the United States Constitution, there's something called the Free Elections Clause, which sets forth how elections are to be governed, in particular for members of the United States House of Representatives. As you know, every state has 2 U.S. senators, but the states have different numbers of members of the House or Congress people because every 10 years under the United States Census, the population of every state is measured and the bigger states get more members of Congress. But then once you know how many members of Congress a particular state gets, who draws the lines as to where these congressional districts are? So let's say you have 10 congressmen or congress people in, let's just say, I don't know, Nebraska or what have you. Who draws the 10 congressional districts in a state like Nebraska? Well, here is the issue that is being litigated. Under Article 1 of the U.S. Constitution, it specifically provides that the manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. And this is very important. It says the legislature thereof. So the question before the U.S. Supreme Court is, what is the legislature? And you may ask, why should anyone care about this when it involves the Second Amendment? And I will tell you why in North Carolina specifically. You see, what happened is that the North Carolina legislature drew these maps of how the Congress, of who would be elected where, or, what are the congressional districts for the 2022 midterm election. They drew these maps. But then the North Carolina Supreme Court, the state Supreme Court of North Carolina came along and interpreted, quote unquote, the state constitution of North Carolina to say that the state legislature, as referenced in Article 1 of the United States Constitution, basically ran afoul of the state constitution. So the state Supreme Court of Judges, also known as lawyers, struck down the map created by the legislature of North Carolina, the elected representatives. And as a consequence of that, the practical reality, in my opinion, based on my best guess here, is that Republicans in North Carolina lost somewhere between 4 and 5 Congress seats, 4 or 5 Congress people who should have been elected, in my view, in 2022 to the Congress did not get elected because the maps, rather than being drawn by the Republican legislature in the State House of North Carolina, those maps were thrown out as violating the North Carolina state constitution by a bunch of judges sitting on the North Carolina State Supreme Court. So the U.S. Supreme Court has taken up this case asking whether or not the decision as to how to draw these congressional maps for the purposes of federal elections under Article 1 of the U.S. Constitution, whether or not the state Supreme Court of North Carolina has the legal authority to step in and essentially tell the state legislature, you can't do this. Because again, the text of the United States Constitution, which is the supreme law of the land, specifically says, quote, the manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, close quote. So how does a state group of judges known as the state Supreme Court use the state constitution to basically rewrite the legislative, or I should say the congressional map in North Carolina when the legislature has a different view? So the U.S. Supreme Court took this case up, and this is a big deal for several reasons involving the Second Amendment. First of all, it's basically the way to interpret the Article 1 of the U.S. Constitution. They're applying, in my view, they're going to apply an originalist methodology of what did the founding fathers mean by Article 1 and the Free Elections Clause? What do they mean by the state by the state legislatures? Do they intend that to include state courts or not, state constitutions or not? So that's an originalist methodology where the U.S. Supreme Court is going to read the text of it's going to read the text of Article 1, and then they're going to apply the relevant history. Sounds like NYSERPA versus Bruin, right? So that's the first thing. You got an originalist analysis, so that's why we want to cheer that the Supreme Court comes out with a ruling that says that the state legislature in North Carolina gets to dictate the maps, the partisan drawing, whatever you want to call it, the maps for Congress districts, congressional districts, and not the state Supreme Court, because that would be consistent with the text of Article 1 of the U.S. Constitution. The second thing, there's the practical reality that if the maps that were embraced by or drawn by the North Carolina legislature were followed in 2022, then the Republicans, which I would say as a general matter are better on gun rights than the Democrats, who are terrible on gun rights, you would likely have 5 additional House members that were Republicans if the original maps in North Carolina were put back into place, which the Supreme Court decision in Moore versus Harper would likely do. So that's the second reason. The last point is the interplay between Bruin's understanding of the Second Amendment and Article 1 as a matter of originalism is not something I've just made up. In fact, it turns out that at oral argument in Moore versus Harper, the lawyer arguing in favor of what's known as the independent state legislature theory, or the independent state legislature argument or doctrine, whatever you want to call it, basically the lawyer arguing in favor of the North Carolina legislature saying that our powers were usurped by the North Carolina Supreme Court, that lawyer actually explained to Justice Kavanaugh and to the Supreme Court right there in oral argument that the way to interpret the history associated with Article 1 of the U.S. Constitution is the exact same way that the Supreme Court just interpreted history in the context of the Second Amendment in the NYSERPA versus Bruin case. And what did that lawyer argue to the Supreme Court?
What about the historical practice over time, which has certainly developed in a way that state constitutions do regulate federal elections? What weight, if any, do we place on that?
Your Honor, we think the way to think about this is consistent with the court's opinion in Bruin last term, where it looked very focused on the time of the founding, 1791. Obviously, we're looking for the public meaning of the Constitution as that founding generation passes away. Adams and Jefferson die on the 50th anniversary of the Declaration of Independence. As we get out of the 1820s, there's very limited information you can get as to the original public meaning of the Constitution. But so it can be a confirming that subsequent history, as in Bruin, can be a confirming historical tradition, but it can't undermine what the text and the founding era history show to be the case.
Thank you.
It's what I've explained repeatedly, that you set the meaning of the Constitution in 1791 or the late 18th century, whether it be for the Second Amendment or for Article 1 of the U.S. Constitution. That's how you define the meaning of these things and the scope of these things. And in the context of Bruin, that's where you look to your historical analogs to determine whether or not a modern-day gun control law can be upheld based on what the law was in 1791. But then you are allowed to look at history after the founding period, but you may only do so for one single purpose, and that was what the lawyer argued to the Supreme Court today, and that is you can look to post founding era history to confirm, to affirm, whatever you want to say, essentially say that our understanding of what the founding fathers thought in 1791 of the late 18th century is confirmed by history after the 1820s. And you can use those to confirm your conclusion, but under no circumstances can any court use historical evidence after the 1820s to undercut the original understanding of the Second Amendment, or to undercut the original understanding of, for example, Article 1 of the United States Constitution as dealing with the manner of holding elections for senators and representatives being prescribed by the state legislature thereof. So whether you're interpreting Article 1 or the Second Amendment, it's the same methodology in terms of using history. That's why we want to look very carefully at this Moore versus Harper case when it comes out in June, is my guess is when they will release the decision, because not only could it ultimately give rise to 5 additional Republicans in Congress in 2024 based on the maps that were redrawn by the state Supreme Court in North Carolina for the 2022 election, but also because the methodology and the way they use history to determine the decision in Moore versus Harper could also be very enlightening and reaffirming of the proper methodology for using text and history when they interpret the Second Amendment going forward. So a lot to be cheering for. Bottom line is you want to cheer for the North Carolina legislature to win Moore versus Harper. You want the liberals that are arguing in favor of the North Carolina Supreme Court to have the power to rewrite these congressional maps in North Carolina. So you're cheering for the legislature over the state courts in this case of Moore versus Harper. And I think it's pretty obvious that places like the New York Times are very unhappy with this. They obviously want courts to be able to rewrite stuff because those courts tend to be made up of lawyers who tend to be very liberal. So when in doubt, needless to say, the anti-gun community and the left-wing community in the United States prefers courts over we the people as a general matter, because in many instances, their Democratic friends on a lot of these courts are willing to, throw out laws they don't agree with on so-called state constitutional grounds. And again, I think Moore versus Harper, if decided right, will be good, not just for the Second Amendment, but for the country as a whole. Okay, I hope you learned a little bit something here. No, it's a little bit off the beaten path, but it's important to understand. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.